next panel discussion. The next panel discussion will be on the litigation and e-discovery, human-centric approach to the legal tech revolution. To discuss this, I would like to call on stage Asmita A. Nayak, managing partner at SM Legal, Dhritimaan Shukla, partner at EY, Sanjay Jain, founder and managing partner at LEX Corp, Sanjay Gulati, EVP, Corporate Tax-IDT, GMR Group. I would like to welcome you all to the
Good afternoon, everybody. Yeah, we started off on a little late schedule. Nonetheless, thank you so much for joining us in session. So the topic is litigation and e-discovery, human-centric approach to the legal tech revolution. So before we delve into the discussion, start of the session, first we'd like to understand why was this a heated debate of recent times? Like what is e-discovery? Why is it so much being talked about? So the very necessity of, what is e-discovery is basically, it's the electronic discovery. So it's nothing to do with the Discovery Channel, if most of you are wondering. It's the electronic discovery of ESI, that is called electronic stored information, in terms of emails, voicemails, text messages, your PDF documents, etc., which have been exchanged or circulated and at request, during court litigations or even government investigation. So that is the admissible evidence in electronic form. So now there are a lot of regulations around it. So that is why this topic is very relevant in today's time, where there's a rapid digitization happening everywhere, and corporates are very interested in implementing this e-discovery as a process in their day-to-day affairs. So coming to that, now the origin of e-discovery. So e-discovery is kind of, the father of e-discovery is Mr. Nikola Tesla, who, it is way back in 1938 that he discovered, a program where he was like, where these information were being transferred over electronic media, over wireless transmissions. He said, why not design a system where these wireless transmissions could be stored in a magnetic tapes? So that was his concern, because he was engaged in a lot of patent cases, against Mr. Edison, etc. And that was his major concern, because where a lot of information which was being transferred during these wireless transmissions, they were getting lost, or most of them were not even making it to the court. So this was primarily what he started. Like, he wanted to develop this system. And so on and so forth, in different parts of the country throughout the decades, somewhere, during these litigations mostly, there were like a lot of information was not being brought to court, or they were like turned down because they were not admissible, because they were all not paper-based evidence, but they were electronic media-based evidence. So finally, what really brought e-discovery to the map was when the US Supreme Court in 2005 ruled out in the case of Zuber Lake versus UBS, where the first time that they designated emails and texts as admissible electronic evidence. So that was the first time when this was talked about, that, okay, e-discovery, it's really important in litigations, and it will really be helping ease out the challenges faced by both the parties. And then so forth. So just to implement that, then subsequently when UK followed suit, they had to change, they brought in civil procedure rules to accommodate to that. Then even in Asian countries, there were a lot of regulations regarding to that. They amended the civil procedure rules and the practice discretion of how to go about it. And then finally, basically how to implement e-discovery, a model was created, which is called the EDRM model, which is called Electric Discovery Reference Model. So that is basically, it tells you the steps of how to implement the ESI, that is the electronic stored information, and bring it into the legal regime. So it starts with identification of the data, collection of the data, then there's a review analysis of the data, of how important and pertinent it is to the litigation at hand. And then finally the presentation, so the preservation, the presentation in the court. So that is how the EDRM model was developed to deal with it. So basically, you just have two types of e-discovery, because as I said, it's used in litigation. So we have a civil discovery, e-discovery, and you have a criminal e-discovery. So be it, sting operations, etc., everywhere. So now all this electronic information that is being shared is now admissible evidence. So finally, so this is how the e-discovery background is. And mostly e-discovery, you can see, is an amalgamation of both the legal and the technical aspect. Because where the legal comes in is identifying what is the important document, and technical is how exactly you're storing it or you're transmitting it and how it is being produced. So with that being said, let me start the first question. I'll direct it to Mr. Dhritimaan. So because he belongs to the forensics department. So Mr. Dhritimaan, how relevant is e-discovery in the forensics department? Like how, and what are the challenges that have been faced? Cyber forensics, mobile forensics, like how it is?
Good question. Well, you've already explained everything about e-discovery. I think there's, in a nutshell, that's what it is about. Okay, so my career has been in forensics all along, pretty much. And you mentioned 2005, and post which we saw a sort of a massive increase in the cases which require discovery, right? And it almost became a norm, both from a mandate, from a regulator perspective, as well as from an internal organization point of view as well. Because at the same time, while the law was being sort of more actively used, there's another thing that was happening. I think the internet was exploding with data. The organizations were creating more data than ever before. And it was not just the legal angle of it, but also your ability to go through this massive amount of data within the organization to come down to that needle in a haystack. And therefore, the forensic profession also started changing. Most of the investigation work that we were doing with hard copy documents, interviews, and other means changed in a drastic way. There was a greater reliance on electronic data. Suddenly there was massive amount of information to go through, and very few means available because the computing power wasn't that great in 2005, maybe up till 2010, 11. However, the data had exploded, and the tools started coming into market, right? And right now we are in a stage where the computation is powerful, the data storage is cheap, the tools are very advanced, etc. So in the profession of forensics, and that's the question, e-discovery has been very, very central, and it continues to be, because there is no other way to do what we do unless we are able to logically, in a legally tenable manner, go through massive amount of data. I hope that helps.
Yes, right, absolutely. So, okay, so now my next question is to Mr. Sanjay Gulati. So you come from a corporate house, from a corporate house. So what are the challenges that corporate houses, of any size, what are the challenges that they're facing when it comes to e-discovery? And, be it coming to the costs incurred or the human resources that are being deployed for it. So what are the challenges that are being faced now?
Yeah, I think that's a very relevant and very patent questions at this point in time when technology is, taking its place, and it's almost in the center of everything. Right from when we see the role of government, and government is highly dependent on digitization, and they have introduced digitization in every walk of their life, and the entire ecosystem of governance is around digitization. So having said that and experienced that in a very short time of 5 to 7 years, like India government has really integrated every governance function as part of the digital framework. And the way the data is now integrated, that every aspect of the business, commercial or regulatory or tax or any such area, is the data is at one place, and that data is being used fungibly, or it is fungible basically. And it is being used for various purposes, whether it is for intelligence, whether it's for research, whether it is for analytics, or whether it is for managing any prosecution or proceeding. Now, having said that, the digitization pace is so humongous, so large. the private enterprises also have to speed up to match that level of governance digitization and an internal digitization framework and ecosystem. So this is very critical at this point in time, but organizations are not that ready. While they are gearing up, because there is no choice now, because if the government and governance is already under that framework, their communication with the government or regulatory bodies will be in the form of data interface or integrated approach, or integration has to be there. So for that purpose, there are two elements which are very key. One is that it involves huge investment. Technology, to introduce a technology, to identify a right technology, and then how that technology is going to be scalable in the business environment, and how they can have a sustainable use over a period of time, and what is the level of investment which will be required from today and tomorrow, 10 years down the line, and how that can really integrate itself as a sustainable practice. That is one point. Second point is that the data and data analytics will play a very vital role. And third, the document retention. Document retention is going to be the backbone of the entire governance and internal governance and regulatory framework. So from that standpoint, are organizations ready? Have organizations started to invest? Answer is they are not in a ready state, but they have started to take certain steps which are very essential and critical for the sustainability. And that is where the organizations are trying to integrate all their business transaction and integration of those transactions with database at one place, repository of documentation, repository of evidence, and document retention policies are largely prepared to meet any eventuality. Now, when this is so, the litigations emerge from business transactions itself. And whether it is arbitration, whether it is tax litigations, whether it is any other commercial or civil litigation, or even why we talk about commercial litigation, we also talk about IP. The most of the IP related challenges can only be addressed if we have a data and document retention to substantiate either the period of use or priority of use, or the use of technology. Suppose if it's a technology related, patent related dispute. Now, how do you prove that there is a priority of use of that technology, or the invention is done by Mr. A, and it has been progressed or further developed, then it can be demonstrated only with the chain of evidence. Now, how do you have that evidence in place? Most organizations actually fail to retain that trail of transactions and trail of data events, which actually establishes your case. So that's where I think currently the organizations and the businesses are at stage one of technology intervention and technology integration, where they are trying to first attend to the supply chain related, finance function related transactions as part of the technology interface, and where right from the procure to pay process, or the HR processes, or the entire supply chain processes actually are getting integrated into the main system. And once that is, and then there are certain transactions of your revenue where you have client database, you have client geographical marketability, and so many factors are there which contribute to the growth of the business. So the analytics come from there. So those analytical tools or technology are in the stage of implementation. Now, whether these technology and tools are identified as one fit size for all? Answer is no. Every organization and every type of business has their own unique, requirement. Even within the same group, where diverse businesses are there, the same similar technology platform may not be suitable. It may have to have its own homegrown systems, or it may have to apply certain integrated systems, maybe diverse systems, but trying to match with the most, suitability, most relatable to each other. And that's how I think the organizations are doing a deep dive study and trying to, identify those areas of matching technologies and those areas where technology can be ensured are implemented. And one simple, and I can, relate from my past experience as a chief compliance officer, that, you have a warehouse. Now, there is a legal requirement and regulatory requirement. If you are storing food items, you have to ensure that and identify the expiry date of the stock or inventory lying with you. Now, that's one of the regulatory requirements. Now, if you have 1,000 tons of material lying in your warehouse or as your inventory, now how do you track the various, expiry date stocks lying with you? That's one simple, requirement. And technology and people have been struggling with the hybrid system, manual plus some level of, RFID tracking or some kind of technology introduced to track the data, but still till date, not so much of success has been achieved in, having the entire trail of this particular important regulatory, requirements which have to be fulfilled. So largely, there is a huge, huge scope. Now coming to our topic of litigation, and in all litigations, as I mentioned initially, that the evidence is the base for successful outcome. And if we don't have that in place, the strong document retention policy or data retention policy, and linking the transactions right from their origin until the transactions have been concluded with certain track of the documents and also track of the event dates. It's so important because litigation journey takes almost, sometimes from 1 year to 10 years. Now that very issue which is in contest before the court, and it travels to various courts, right from the first appeal court to the Supreme Court, you can imagine the time involved to resolve that litigation, and how do you ensure that at the point in time when you need that one single document or data or relied upon document, if that is not there, how it takes? What would be the fate of your litigation? One original piece of document is needed at that very moment to prove your point. And all these litigations, as we discussed, whether it is arbitration, commercial, IP, or any other litigation, require the base is the evidence. So that's my take, and where the industry is prepared at this point in time. And last point I would mention is industry is largely investing into technology where their core operations are impacted. So that is where they start with their investment into, and what are the support functions. The interest in building that value chain is less. And thereby, I think that is the weak area of any industry. You name global companies across.
Absolutely.
Yeah, thank you.
Thank you, Mr. Gulati. That was very insightful. My next question is to Mr. Sanjay Jain. Mr. Sanjay Jain, you come from a law firm background. So my question to you is, what are the challenges, like how is the legal fraternity adapting to this e-discovery? What are the challenges they are facing? And do you think, they can actually go hand in hand, like when it comes to the law firm?
Thank you, Asmita. It's a very good question. My first question, which I presume that it would be in everybody's mind, that you are having too much of data. You have an access to the data. There's so many acts. What will you do with that data? You will compare it, you will fetch the data. But what about the analysis? This is being done by artificial intelligence. It is saving a lot of time for all the law firms or lawyers. It helps in processing the analysis. It has its own merits, it has its own demerits. And it is at a very nascent stage. Recently, if I know, everybody must be aware, there was a heat-up discussion whether artificial intelligence will take away the lawyers, will replace the lawyers. It can never be so. But at the same time, artificial intelligence helps in saving so much of time for the law firm to process. It helps you to understand what are the precedents. It helps you to devise the strategy for your clients. It helps you to save time. It helps you to become economical. My friend told, just now Mr. Gulati told that it's cost involved. But at the same time, it saves cost to the law firm, to the clients. And within less time, in more economical ways, you are able to find solutions. In India, I'm particularly talking about India because I am from India. In India, we have recently started adopting artificial intelligence. The Supreme Court, in the last week of February this year, have started online transcriptions of the live proceedings. That is only through the use of artificial intelligence. And one such case recently, which happened in Punjab and Haryana High Court, a judge, while deciding a case on bail in communal rights and murder, sought comments from Chat-GPT, which is an artificial intelligence app, that what is their comments with regard to bail jurisprudence. And they gave their opinion, though the judge clarified that it was to have a broader look, but they gave their opinion. So processing of data, which is being collected digitally everywhere, is to be processed. And it can only be processed with the help of artificial intelligence. Artificial intelligence, certainly we need tech-savvy people. We need a law in place to regularize the same. In India, coding is being made mandatory for all the students beyond 6th standard. So we are gearing up for that era where data is being processed, data will be utilized by tech-savvy people. Till then, this is a gray area. I hope I'm able to answer your question.
Absolutely. And I would just like to add to that because myself come from a law firm background, that anything that e-discovery, so I think it really should be put in the curriculum of law schools, because what is happening is those people who are non-litigating lawyers or non-lawyers, they start hiring companies who kind of do information system managers, etc., who kind of really look into this preservation and analytical aspect of it and providing whatever is necessary. So if it's inducted in the curriculum of law school, so the lawyers are well prepared to know exactly what they're dealing with. So if any litigation comes, so they're also able to identify the documents instead of really relying on third parties to do the same for them. So I think this is one of the major things that should be included. And also the very fact that, when it comes to the very litigation, the high stake matters and where a lot of bulk documents are there. So, definitely AI comes and plays a role where it really identifies what the thing is. But ultimately what I say is that they're superchargers and they can't really replace the human mind. So that is my take on it. And to that I'll come to Mr. Dhritimaan.
Just to add, I
Yes,
think
please.
the best part of AI and machine learning and all these technologies is that now you have the information, global information available to you on your desk in a fraction of minutes or seconds.
Absolutely.
So that information was never available with us before. And people used to struggle gaining the knowledge of what happens in the other jurisdiction. today, I mean, by pressing that, what is the law on that very point across the globe in different jurisdictions, how courts have dealt with those issues, I think in fraction of minutes on your desktop, you get that. So that's the beauty of artificial intelligence, that the speed and the volume of data it can process.
Absolutely.
And that acts as a real enabler to everyone, whoever, I mean, the sphere of work, one has.
Absolutely. So coming back to Mr. Dhritimaan, as you said, like, forensics and e-discovery, like, they pretty much go hand in hand. So what I wanted to ask you is, have you in your organization faced some really potential forensic hazards, which has kind of made you think sometimes that, okay, like, maybe e-discovery was the human mind was better, or the human way of doing it, the traditional way of doing it was better rather than really going for e-discovery? Like, have you faced ever any this kind of a challenge in your company?
Okay, so I'm a consultant, so all the challenges that I would have faced would be for clients. So with that disclaimer, um, not really actually, but other way around has been very, very true. We've had cases where we've seen that either the client or whoever the client was using went about a forensic requirement without going through e-discovery, right? And they reach certain conclusions. Now, the problem with those conclusions are twofold. One, you're not sure whether you know everything because you've not gone through everything. So, so anything that you conclude will be based on whatever limited procedures you've done, and therefore they will inherently carry limitations. The second problem is the chain of custody or the chain of evidence problem that Mr. Gulati was alluding to multiple times. I think it's very important that every exchange of data within or outside the organization is captured in a manner that you can trace it back. These two, in my view, are sort of the fundamental problems that you face if you go about doing discovery without using the discovery methods. Third thing would be cost. Obviously, I think it will be a lot more costlier not to use technology for something like this. And I think there was this another question that somebody was asking around artificial intelligence and use of AI. And maybe I'll pick that up as well because that will be a question for sure. So it's a very hard concept to explain, but let me try. Now, see, discovery is about going through tons of documents to find what is relevant for you, and that's what we called as the relevance of what you're doing, essentially. So how many relevant documents are you finding as a ratio of not relevant documents, for example? Now, when you do it using human beings, you would use various techniques to reduce your population down by using keywords, date ranges, etc., to cull out anything which is not relevant, even before you start reviewing. And that reduces the population, and that's one way of doing it. Even after that, given the amount of data that we deal today, you still could land up, depending on what the matter is, into millions of documents to review. And that's where I think recently we've seen last 4 or 5 years, technology-assisted review or AI-based reviews have started coming in. They're very effective. There is a way to manage it. And again, there's a way to document what you're doing so that, again, it becomes legally tenable. Obviously, I think the law firm involved or the legal counsel involved plays a very important role in it because he has to understand what's going on. AI tends to be a very black box. Generally speaking, it's you don't know. You just know that it is happening, but you don't know how it is happening. So you need to find out certain markers of it. In the e-discovery world, we call it precision and recall. So recall is your ability to recall relevant documents vis-a-vis not relevant documents. So for example, if a human being goes through 100 documents and finds 20 as relevant, and AI finds 19 as relevant, then you would have a recall of 19 by 20, for example, right? And the second thing would be precision. Precision would be how accurate the AI model is. So do I need to go through So when I looked through 100 documents as a human being, I found 80 is not relevant. But when the AI does the same thing, would it find 90 is not relevant, which means my precision is low. That means for me to find 20 documents, I need to run the model again and again, right? And increase the precision of it. Well, these are the fundamental two concepts. And then obviously, I think there's a whole lot of AI-driven statistical things that come along with it. But in a nutshell, what I'm trying to say is that AI is absolutely real. It can be used. There are use cases of it that have been accepted. And it saves a lot of time, and it saves a lot of cost. So one should not shy away from using it or trying it. All you need is just make sure that you do it properly, document it properly, and can be others can understand it.
Thank you so much for that, Mr. Dhritimaan. Coming back to Mr. Sanjay Jain. Mr. Jain, how do you see the adaptability of e-discovery in the developing countries, in terms of the laws governing them? What are the changes, or what are the legal procedures that has to be added on a daily basis, thinking about what is happening around the e-discovery genre?
See, e-discovery is the necessity of times. In India, I'm talking about developing countries like India, we have no option but to go for it. Because the data, huge data is there. But it has to be regulated. And the norms are not in place. Because nobody is aware about the challenges which will be coming forward. They are in the process of organizing a regulation for the same. But presently, like a breach of data protection policy is not in India at this moment. Maybe in the other parts of the world it is there. But indirectly, they are securing the data. Like data privacy is the fundamental right as designated by the Supreme Court of India, and it is assured by the Constitution of India. Even otherwise, if your data is manipulated or misused, it is covered by the Information Technology Act, and you can see compensation under Section 43A and 73A as the case may be. So regulations are in place. The regulations are under formation. Ultimately, it has to be regulated. Till then, we have no option but to adopt it in the most safest manner. We have to trust the softwares because the software will devise the algorithm on the basis of which you will arrive at a result. If the algorithm is not proper, you may not arrive at a right result. So for that, you have to be little vigilant. Rest, there is no other solution but to go for artificial intelligence, which is required, which is the need of the hour. Because of the huge availability of data, number of multiple acts, number of judgments, statutes, it is required. So this is what is the present scenario for the developing country.
Right. Thank you so much for that, Mr. Jain. Coming back to Mr. Gulati. Mr. Gulati, what you think, apart from the corporate houses, what do you think you would offer as suggestions to the government or to the legal fraternity from a corporate house point of view? Like, what changes would you like to see for them to do, which would ultimately be adapted by these corporate houses, globally?
First is the important thing is the organization have to act in a responsible manner and to act in compliant with the regulations in place. And in order to achieve your business objectives, it is very important that the data or the use of data has to be in compliance with the laws. Whether it is Information Technology Act or whether it is advertising regulation or it is pertaining to any other use of data of a third party, or while you are undertaking a manufacturing process, are you ensuring that such data, what is your base to do a manufacture? Or in real world scenario, if a pharma company is producing a particular drug, the the source of manufacturing that particular formulation, is that compliant? Is that formulation their own invention, or is it through a proper assignment or IP rights? With those IP rights they're manufacturing, and how they are storing the data of any research and development, or in what manner the organization is retaining the data of a third party, or applying the data of the third party, or doing analysis of the data, and in what form can it publish that data, or their research, or their any such communication. So because there are number of regulations which have created certain reasonable limits within which anyone can operate and behave, it becomes very pertinent that they, in current scenario where regulations are now, there are regulations which take care of those violations or provide guidelines or procedures, like EU data privacy law is one of that which is globally being followed.
Right.
Now, most of the governments across the globe, because of digital penetration and digital interventions, and the data flow is global now. It's no more restricted to one geography, or business or commerce is no more restricted to one geography. Now then, how does that need to be regulated? So it becomes, it's no more across border. It is a borderless transaction. And the communication of all this is going borderless. But still, there is a governance in place in the respective countries. So how do you operate your global business, securing yourself from the regulations and be within the framework of those regulations? There is a need to have a full compliance program in every organization backed by technology. Means the data, technology, etc. help the organization to really create their compliance programs with regard to their type of business. So that's where I think it's a two-way process. Regulating governments have to ensure that there are suitable, right regulations, and it should not be too restrictive or too imposing that one cannot operate or conduct its business. And thereby the businesses have to ensure that those regulations are rightly respected and implemented through a proper and effective internal compliance programs. So that is where I think now, going back and forth, it is becoming very important that the organizations put the structure in place, and whether it is your routine business transaction or non-routine business transactions, how do you capture the behavior of those transactions becomes very important.
Right. Thank you so much, Mr. Gulati. That was really lovely. So with this, we just end the discussion of the session, and we leave the floor open to the audience for any questions. So we'll be happy to answer. Yes, please.
Thank you for interesting session as well. My question would be, I think, based on two key notes or statements which I heard from the session. The first one is that evidences and proofs are very important for the litigation and all the procedures. The second one is, unfortunately, we are in a reality where we have different technologies incorporated by different companies, so there is no unified platform. But when it comes to litigation and the court proceedings, with usage of the evidences, which also might be in digital format, how do you think how we can protect the proceedings from usage of the falsified evidences, which can be provided in a digital format? I mean, documents, but can be falsified, and based on that, unfortunately, we might face the fact that the ruling will be not in our favor, for example, if we are defending our rights. So, like, on top of my mind, if there should be kind of security third party, I don't know, specialized experts who should like make a screening of these evidences before the judges will make the rulings, or any other solutions.
Would like to take? Okay, so to answer the question, see now e-discovery basically it's about, you know, electronic evidences that is admissible. Now exactly how, coming to the nature of it, whether, you know, whether it is a forged a document, whether it's a falsified document. So normally in e-discoveries, you can't really forge. It is very impossible even to, you know, destroy e-evidences or even to tamper with e-evidences. So now the thing is, when these, when the other parties, they ask us or they request the e-discovery to be produced, so that is then taken up to the court to exactly determine how far, you know, that is admissible, or how far it, if the other party is challenging that, okay, these are false documents or this is falsified, well, that nature, a company who is producing the e-discovery or the party who is producing e-discovery, they won't be able to challenge that. That is for the court to determine, because it's as simple as even traditional discoveries. You know, when you testify a witness or when you get subpoenas against them, exactly whether they are saying the truth or they are saying the false, that again ultimately has to be decided by the court. So, you know, so relating to that, so basically all you can say is that this is mostly of admissible evidence, but exactly the true nature of it, that can only bring out, you know, during the court proceedings. So if I may have answered the question.
I may also add to this is, we have to understand the source of the evidence from which it is coming. If it is coming from a very authentic source, then it is very difficult to say that it is a forged evidence. And normally, if in digitalization, in the world of digitalization, it's very difficult to forge a document without a source. The first source will always contain the original document. And if the document produced before the court is a forged one, you can distinguish it, because you have also the right to have access to the source of that document. So it's not that easy to produce a forged document in digital world.
Yeah, very true. And just to add on to what Mr. Jain just explained, I have a real life example, and whereby just this month itself, one of my friend who's, you know, contesting an arbitration, and he called me and he discussed a challenge during the course of, you know, production of an evidence by the opposite party. And the opposite party had tendered certain documents which were fabricated, false and manipulated documents. Now, the role of the defendant here is, or the party who is contesting that particular arbitration, is to object and to raise, you know, questions on the authenticity or validity of the documents. So it happens that the mail relating to a particular transaction has been fabricated and manipulated to put the generation of that particular mail, that it was released at that very point in time and with the certain content. And when the facts have been seen, there was a distortion and contradiction between the time mentioned in the email and the reliance placed as evidence on record in the form of a statement. So there was a complete disconnect between what he stated, made the statement, and the document produced. Both had a different time. And it was discovered that actually the email was fabricated. It was generated through some way to manipulate it, to be looked at as if it was circulated, really circulated. It was not circulated. It was produced, manipulated, and, you know, created. So the evidences are placed like that, but the way to address this is that this particular, if one is able to sense that there is a false evidence being placed, one can really apply it to the regulatory authorities to validate that through a forensic audit or through any other mechanism, where the source document, real source document emerge. And even the person has filed a false affidavit of his presence in the country at the point in time he was not present in the country, while he placed it that, the affidavit that he signed the document when he was present in India, whereas he was not present in India. So the question is that it does work, it does happen in the real life, and how you can really ensure that the business transaction documents are retained and repository is created at the time the transactions takes place. Because 5 years down the line, you don't anticipate that you may have to enter into a litigation with your client or customer or supplier or anybody. So that's very critical, that through the trail of documentation maintained. And one more reality is that today people change in the businesses, and people change so fast that who is going to remember the story of 5 years back, how that transaction took place, who did what was the real terms of negotiation, has that been documented, has board decisions being documented and retained, and then how those have been made the basis of any litigation tomorrow. So there are a couple of instances which we have to keep in mind, that technology is only going to be the base which is going to stay, but people will move. Yes.
Digital signatures cannot be forged. You get only one key. I don't know whether you are aware of this or not. In India, particularly, you get only one key, and it is used by the person who is authorized to use it. Suppose it is my digital signature, so only I'll be using it. So digital signatures cannot be forged. There was a time when they were introduced, 2-3 copies were given, but now it is not. If you have lost your digital signatures, then you have to report it to the government, and you will get fresh digital signatures, not the copied one. So the signatures are different. So using a forged digital signature or a forged document, using a forged digital signature is out of question in today's scenario. Have you asked this question 2 years back? Position was different. But today's scenario with the digital signatures, documents are very secure. And digital signatures are the futures. Even the filings will take place with digital signatures.
Give the key to somebody else of your, typically what happens is that you have given to your accountant to file your tax returns. You pass on your or ROC filing, you give it your key to somebody else, use my digital signature and upload it. Actually, ideally one is not supposed to do that. And that is where there is a possibility of your somebody's digital signature getting misused or misapplied.
Okay, so just to add, if you meant by digital signature is copy pasting somebody's signature, okay, so actual digital signature, oh then yes, I totally agree.
So I guess with this we can wrap up this session. Oh, sorry, we can take one more question. Yes.
I'll pass it on.
Thank you. So what I was stressing that digital signature, only few people use it. And now it's more like concepts like DocuSign, then there's QMS, and now the latest is scanned copies, where you're actually signing the documents, uploading it over the email and sharing it. So at a bank level, we are trying to get it to that level. So what's
So
the
if-
forgery and fraud aspect in that?
So if you don't use any secured medium of signatures like DocuSign or digital signature or the key fob or something like that, you merely copy pasting signatures on a PDF document and uploading it, then yes, uh, you would encounter forgery.
That's what we're trying to
But
get
there
to.
are techniques to detect it. So whenever somebody sort of manipulates a document, generally speaking, whether it's signature or anything else like a receipt or a invoice, etc., person will use some tools like Photoshop or Word document or whatever, and they will try and paste things. Usually, you would see image distortions. So either the image will be, the aspect ratios are off, or the metadata has gone wrong. There is always an indication that something or the else has been done with the document to manipulate it, unless the person is like a super good forger. So there are ways and means to find it. Now, using technology and especially AI, machine learning models, you can actually find image distortions, contour analysis. You can use convoluted neural network, etc., to find whether it has been pasted, whether it was already part of the document. Usually, you will find it. And then there are obvious other signs also when you're looking at forgery is there will be always an information. Sometimes there will be information distortion as well. You'll find two different type of information on the same document, obvious mistakes, etc. So, so yes, it can be done unless the person is like very, very smart. Then maybe it's very hard.
So coming from a service sector, this is what the business wants from us. And the legal is pushing
Your
back.
voice is not audible. Can you
So,
please?
so coming from a service sector, this is what the business wants from us. They want the most easiest method is scanning and uploading it over the email. So how fast should we push back, being from a legal fraternity and looking at all the frauds which are happening? Should we say yes to the business that yes, go ahead with this?
My view is we should not indulge in copy pasting signatures, but I have many lawyers on the podium, so maybe they can.
See, if you copy paste your signatures, you are more prone for a fraud.
Yes, we are in a time crunch, so we'll wrap it up.
Thank you so much.
Yeah, absolutely, no problem. Yes. Thank you so much for being such a wonderful audience. Thank you.